right. Good morning, good afternoon, good evening, everyone, whatever time of day it is where you are. I hope you're all doing well. Today is our 30th construction clinic, and Cagdas has kindly left the topic open. So it's exactly whatever questions you have is what will be answered today. As usual, we do give priority to the questions asked in advance. And as always, I jump right in with a quick introduction of the ICCP. So if this is your first time joining us, welcome. I hope you find my little introductory information useful for you to explain who we are and what we do. And if you are returning, welcome back. Glad you found us useful enough the first time to come back for more. All right, and with that, I will go ahead and share my screen. 1 second. So, who is the ICCP? Who are we and what do we do? Well, we are a professional members organization that exists to recognize the skills, qualifications, and expertise in the professional management of construction claims. We have 3 primary objectives. Those are to establish international standards for the management of claims, to give recognition to those who have gained the appropriate knowledge and skills in the management of claims, and also to help and educate those who would like to gain that experience and develop their claims to the highest of professionalism. So why is there a need for the ICCP when there are so many construction organizations out there? Well, quite simply, claims have become a key part of the international construction industry. And although there are many professional organizations within construction, until the ICCP, none of them have focused on claims. And additionally, our members come from a broad variety of backgrounds, from quantity surveying and engineering to project management, contracts management, legal. There is an extensive variety of backgrounds that our members come from, and they deserve the recognition within the industry for their claims skills. And until the ICCP was established, there was no institute that specifically recognized those who have the specialist knowledge, experience, and skills to manage, prepare, and respond to claims with the highest level of professionalism. Okay, so I will quickly introduce our steering committee. I'll point out that we have an executive officer, our founder, Andy Hewitt. We have an elected president and 3 elected members, fellows. You may recognize one who will be leading today's session, Cagdas Bayrak, and Nina is the general manager. She is currently on maternity leave, and I am filling in for her. Okay, in terms of membership, we have 3 levels of regular individual membership, and each of those have their own set of criteria. We also have 2 levels of membership for students who are seeking their first degree. And we also have corporate membership. We have recently streamlined our corporate membership process, made it easier to apply, and just simplified it all around. And corporate membership is available to companies that specialize in claims or have specialist claims departments. Okay, and what is in it for our members? What do our members get out of their membership? Well, we have a private area of our website, which has a knowledge bank, which is a collection of articles, white papers, research, etc., on contracts and claims topics. We have a collection of education and training resources. These are informational only. It's not provided by us, but it is collected in one place where our members can go for further education and training. We have a bookshop which doesn't sell books. Again, it is a collection in one place where our members can see the latest releases, what they're about, what people are saying about them, and links if they would like to purchase them offsite. We have a growing bank of practical templates which help our members refine their claims administration and skills, and ensure that their claims are completed to the highest standard, and also saving time. We have CPD events like this one, so our members will receive CPD certificates for attending today's session. We have the ICCP Academy, which are also webinar training sessions, but those are for members only. They are more technical in nature. We offer discounts on books and training through our training partner Claims Class. We have a monthly newsletter to keep our members up to date on the latest within the industry. We offer industry exposure in the form of a public listing of our members. Members also receive logos and certificates. And we have a private LinkedIn group where our members can discuss their contracts and claims questions. They don't have to wait for a session like this one, and they can use the collective knowledge of the membership as a whole. We also have the optional benefit of our Register of Claims Practitioners. If our members would like to have their own webpage, which highlights their career and experience, that is a popular option with our consultant members. Okay, I realize that was very quick. If you requested more information when you signed up for this session, I will be sending you an email with some more information after this session. Otherwise, feel free to visit our website, instituteccp.com, or email me, jennifer.smith@instituteccp.com. And with that whirlwind tour, I will hand the session over to our presenter today, Cagdas Bayrak.
Thank you, Jen, and hello, everyone. Thank you for joining. You can see my screen now, right? Sorry.
Yes, I can see it just fine.
Okay. I am Cagdas Evren Bayrak. I'm in the FIDIC President's list of educators. I have 2 postgraduate degrees in construction law. I'm an engineer. I'm a fellow member of Chartered Institute of Arbitrators, of course, the ICCP, and some other things. So let's start with the first question. Can contractors claim a time extension if the engineer elongates the period of approving the submitted materials? What tool we can use to approve that, or how we can prove the elongation? Is the person who raised the question, is he among us now, Jamal? Okay, so if this question relates to only submission of physical samples of the materials, then of course, depending on the applicable conditions of contract, it's not as straightforward. I mean, there's no in FIDIC 99 or even in FIDIC 2017, there is no specific, provisions in relation to, let's say, delayed approval of the samples, because it says the contractor shall submit the following samples of materials. As you can see, materials is with capital M, whereas samples is like a normal word. It's small letters, starts with small s, and relevant information to the engineer for consent. So it says for consent. Consent is one of the words used in the FIDIC book. So yeah, it means for I would say it means for approval, but it doesn't give a specific timeline, or there are no deemed approvals in this clause. So if the question only relates to meaning, there's a specification. In the specification, let's say there are 3 accepted manufacturers for a certain thing, whatever it is, and in accordance with the specification, the contractor submits samples from these 3 preferred vendors or accepted vendors to the engineer and the employer ultimately for, let's say, for the touch and feel and aesthetics of the materials. Okay, as long as what is submitted is in accordance with the specification, then sensibly it shouldn't take long for the engineer or the employer to come up with a comment in relation to merely the aesthetics and touch and feel of the samples. But again, there is no, in the conditions of contract, I'm talking about FIDIC conditions of contract, there is no specific timeline for it. There are no deemed approvals in relation to samples and so forth. However, you need to look at the specification, of course, or the employer's requirements. And because in many, let's say, standard specifications, off-the-shelf specifications, I tried to find something in the American Institute of Architects, but I couldn't. But I remember something like that. I need to double check on that. That means usually specifications may have such time durations for samples. Which means, let's say, within 14 days, if the engineer or the employer doesn't respond, then the sample is deemed to have been approved. There may be a condition like that, but in that case, you need to check the applicable contract documents or the specification for it. But if this relates to not only the sample, the physical sample, but let's say shop drawings as well, because usually when the contractor makes a submission, it's like a bundle of things. You know, they submit the shop drawing, and usually, I mean, of course, always it's not the case, but presuming if this is like a bundle submission with the shop drawing and with the physical sample, etc., then these may be different things. Because a shop drawing, after all, is a contractor's document, and and being a contractor document, however, it's, let's say, extension of the design. It is, yes, it is produced by the contractor. However, it's an extension of the design. Therefore, if the specification, as I said before, if the specification is silent about such deemed approvals for samples or contractor's documents, shop drawings, etc., then, again, depending on the submissions and depending on the contractor's design scope and everything, perhaps delayed drawings and instruction clause may kick in. Because usually, when it comes to shop drawings, you submit something and the engineer comes up with additional comments, most of which usually may constitute additional work to the contractor. This is very common. I can say almost 30-35% of all the comments, in average, of course, from the engineer, from the design consultant in relation to shop drawings, are considered by the contractor as extra work. If that's the case, then it's a different mechanism. And in that case, if such comments relate to a design obligation of the employer, then clause 1.9 may be relevant. Or if such comments constitute, or if the contractor considers that such comments necessitate a variation, necessitate an instruction which would constitute a variation, then another clause applies. But again, if we are just talking about the physical samples for aesthetics, touch and feel, then no, there is no, at least in the FIDIC books, I would say, there's no predefined, straightforward way of claiming extension of time. But again, I mean, as long as you submitted the right thing as per the contract, as per the specification, it shouldn't take long for the engineer or the employer to respond. In case of a clear requirement in the contract and the specifications, I would say this should be made. I mean, the response should be given within a reasonable time. What constitutes reasonable? It depends on the applicable law, depends on the specifics of the material, depends on many things. But let's say if you're talking about, I don't know, a lighting fixture, and if the engineer, kept this on his table for 3 months, then yes, of course, this is unreasonable. In that case, the contractor needs to claim If the engineer, does not play ball on this claim, then they have to consider the dispute mechanism under the contract. What happens if they operate the dispute mechanism under the contract? If it goes to arbitration or if it goes to court, if the arbitrators are not in the position to decide, but usually arbitrators or adjudicators are experienced construction professionals, so they have an idea as to what would be reasonable for approval of merely sample. But judges usually they don't have this experience, so they refer to an expert, and whatever the expert says, they will follow. Okay, guys, moving on to the next question. This is an interesting question, and I think it came from someone based in Qatar. It has two parts. Part one is, given the recent introduction of the Trade and Investment Court in Qatar and the potential drawbacks associated with expedited court procedures and inexperienced court-appointed experts, what kind of role do you see for yourself and other industry professionals in promoting the use of ADR mechanisms, especially for complicated construction claims such as prolongation, disruption, and acceleration that require delay quantum experts to review and seasoned experts to assess entitlement and quantum? Yeah, this is a good question, because the Investment and Trade Court or Investment and Commerce Court is a very, very new thing. It's been introduced with a new law, law number 21 in 2021, and still, people are testing it, if you will. Like myself, I haven't had a case that I submitted to this court per se. There is one. I'm really drooling all over the place to test this court, but I'm so busy, so I don't know. Maybe I will negotiate with the other party. But the thing is, I'm hearing very good things about this court, because like many Gulf countries, there's a construction boom, and cash flow of the contractors' cash flow is a very, very serious issue. And there are, of course, a lot of construction claims, and these claims, when when escalated, it takes forever to resolve. That's why this court has been established, mostly, I would say, to deal with construction contracts, disputes under construction contracts. They adopt a fully electronic submission methodology, meaning you submit everything online, and it's an expedited process. The durations for appeal, etc., are very short. And for example, if you cannot submit evidence which you had or which you should have before making your submission in the first place, so there are no in the middle of the court submissions allowed. So in general, it's a good initiative, and one of the good parts, or I would say maybe perhaps the best part, is it facilitates the appointment of party nominated experts. So when it comes to complex construction claims, finding court approved experts who are really seasoned in claims and quantum and delays and associated claims was a challenge in Qatar. For example, I helped someone. Actually, I did all the work, to be honest with you, but I was, let's say, the ghost expert on a very, very big case, on a landmark case in Qatar. And I know for a fact that the guy literally did nothing. I mean, he had very poor understanding of the very fundamentals of the contract, and it was really dangerous to trust this guy for literally $1 billion case. So I welcome this change. I think this is a very good step in the right direction, allowing parties to appoint their experts. That being said, of course, the court has still have the liberty to appoint additional experts, and that also happens quite oftenly, because both parties, they have their experts. They're usually experienced people, good people, and they amplify the facts and circumstances which would help their case the best. So when the judge sees two good submissions, he gets confused and he refers to an expert. But still, I mean, this is a new thing in Qatar, and I think it's a good step forward. There's a second part of this question, which is like a continuation of the first one. In your experience, what are some best practices for navigating the potential pitfalls of the trade and investment court and leveraging ADR mechanisms to ensure fair and efficient resolution of complex construction claims in Qatar? And what kind of involvement, if any, should government authorities, as well as other bodies such as the Qatar International Court and Dispute Resolution Center, QICDRC, and the Qatar International Center for Conciliation and Arbitration, KICA, have in supporting and promoting the use of ADR mechanisms in the local construction industry? Well, when you talk about the the potential pitfalls in relation to this new trade and investment court, as well as any court for that matter, is that similar to every country, this is not specific to Qatar. Sometimes, let's say, the things may get out of control for both parties. I mean, sometimes the judges come up with a conclusion which may surprise both parties in the first place. So that is why the ADR mechanisms were born in the first place. Not only speed, because right now, arbitration takes almost the same amount of time as litigation, but it is the freedom of the procedural requirements, as well as finding the right guy to be the judge of your dispute. In Qatar, well, first of all, I'm a big fan of Qatar International Court and Dispute Resolution Center, QICDRC. They're under QFC, Qatar Financial Center, and perhaps similar to Dubai and other countries, this Qatar Financial Center has its own jurisdiction. It's like a separate small country, if you will, and it has a separate court. This court is transparent. You can literally watch all their hearings online. All submissions, except for those which are commercially sensitive, are open to public. There are very good legal reporting means. The judges are very experienced and respected, and it's common law based. So when you raise something, you have an idea as to where it may lead, unlike the litigation. Is there an answer to the question? Bashir, you raised this question, the question regarding the Trade and Investment Court. As I said, I'm a big fan of the QICDRC. I think they're doing a great job. Unfortunately, I cannot say the same for KICA. I mean, they're under the Qatar Chamber of Commerce, and if I have to make a choice, if I need to choose between the two, I would easily go with QICDRC. KICA, they have no separate jurisdiction as such, and I have to say, but the overall skill set of arbitrators and experts is something I would I would be concerned about. So my recommendation would be, and this is something that I do in the like my own retainer with companies, I always assign QIC-DRC as the competent court. This can be done. This is clear. There were some ambiguities in the past in relation to choosing QIC-DRC as the competent court for non-QFC entities, but now it's clear. Even two non-QFC entities can delegate or can appoint QIC-DRC as the competent court for the purpose of their disputes, and even again for non-QFC entities, such decision of this court would be equally binding as if it was made in regular courts. So this would be my recommendation to people who are looking for a swift, more predictable way of resolving their claims. As I said, I'm doing this for all my personal contracts. I mean, in all my personal contracts, the competent court is the QIC-DRC. There was a very good initiative, a very good idea many years ago when I first came to Qatar. So I think it's like 10 years or something. It's called the Q Construct. The Q Construct was basically an adjudication scheme on the Qatar Financial Center. It was a very good idea, and they prepared very well. They had all the things in place, but for some reason it didn't come through. In countries such as Qatar, as everybody knows, and as I mentioned before, cash flow problems are very important. I mean, you may have a dispute with the contract, and I'm sorry, but this should not affect the progress of the works. You shouldn't be waiting for years for a claim or a variation to be resolved and paid. That's why these statutory adjudication schemes are very helpful. For example, in the UK, there's a statutory adjudication scheme, and the adjudicator needs to make his decision ASAP, maximum, let's say, if I recall correctly, it was 84 days or something. So this kind of pay now, argue later kind of schemes would be very helpful for, rapidly developing countries like Qatar, Dubai, now Saudi, all these. But unfortunately, it didn't come through. And after almost a decade, they came up with this new court, Trade and Investment Court, which is a court, as you know, it's a court. But yes, you can observe the expedited procedures and everything. So it's a step in the right direction. Moreover, mediation, especially evaluative mediation. Evaluative mediation means, because in normal mediation, the mediator just tries to facilitate an amicable settlement between the parties, but it doesn't get involved in the dispute itself, and he or she does not share his findings in relation to the dispute itself. Whereas in evaluative mediation, it's mediation plus the mediator, if the parties cannot agree, he comes up with a non-binding decision or a recommendation. And Qatar was one of the first countries which signed the Singapore Convention regarding the mediation. So this, I would say, this brought a certain momentum for mediation in Qatar. Like, I have some few accredited mediators myself, and they are saying that they are busy these days. They are keeping things busy, So it's definitely a step in the right direction, and mediation, of course, is very helpful when it comes to resolving disputes. Bashir is asking, I want to ask, how can ICCP as an institution help in enhancing Qatari expert and arbitrator skills? For example, can there be some kind of collaboration with KICA and QIC-DRC or locally held seminars and workshops? Well, if I have the time, I can do that. I mean, I have a lot of friends there in both institutions, and I can do that, but for that I need to have time. And moreover, and this would be like a friendly session instead of an official collaboration, because ICCP was asked to provide uh, uh, like expert services and even expert appointment service or adjudicated appointment services, etc. Before we discussed this in the steering committee, and we decided that no, this is not the route we want to go. So yes, we are of course always open for such informative sessions with KICA, QIC, DRC, whomever. But when it comes to like an professional as in that which would require exchange of funds, then no, we're not very interested in these things. And to be honest with you, QIC, DRC are more open-minded, but KICA guys are not very receptive for such things either. They think they know everything. But anyway, I mean, this is of course doable. Okay. So I'm moving on to the next questions, and then I have some other questions from Clarence. Okay, just a second. Yeah. My contract is a 3-year contract with a price adjustment clause. Okay, the contract period has been extended to 5 years due to employer's delay and some instructed variations. EOT has been granted, however, due to high inflation, the contract is complaining that they are not fully recovering the cost of materials from monthly price adjustment indices published by the government. They have proved that they are losing money on cement, rebar, and fuel, considering the applicable monthly price percentages when the tender price is compared to the actual invoice prices. My question to you is the contract entitled to recover such evidence costs on the prolongation claim, which is now under preparation? Okay. Well, of course, it depends on the provisions of the contract and the applicable law. But I would say there are two separate limbs of this case, this situation. First, there's the variations and the employer culpable delays for which the contractor is claiming extension of time. So when it comes to variations, there's one thing you need to bear in mind. I mean, when you sign a contract, you're not just signing the original scope of works. You are signing the original scope of works plus or minus the varied scope. And if the contract provisions in relation to valuation or variations does not allow escalation, in this case it allows escalation, but not to the extent which the contractor would be happy, then I would say it's difficult for the contractor to reject the variation or make a separate additional claim in relation to asking for a higher margin. Because consider this the other way around. Suppose that the inflation or whatever the price, whatever the formula introduced in the contract and the market conditions, the new market conditions, I mean, after the expiry of the initial term, suggest that the contractor would make more money than anticipated in the first place. Would the employer have the right to deduct such sums? No. So it's a commercial risk which the contractor, as an experienced and well-informed party, has or should have scrutinized and accepted accordingly. But that being said, of course, that also has limits. But I would say in the ordinary course of business, I would say this would be a difficult claim. I'm talking about variations now. Okay. And as you know, there are basically two types of variations. There's the agreed variation and there's the instructed variation. So for larger scope, wise employers, they try to go with an agreed variation because they don't want hiccups later during execution of the variation. So if this will be an agreed variation, then the contractor should be, should play it smart, and they should highlight this situation, especially if they prove they can demonstrate to the employer that, Mr. Employer, yes, we're willing to do this additional scope for you, but these are our financials, so we need some sort of a compensation, additional compensation in this regard. And since this is an agreed variation, I would say the chances of the employer accepting this will be higher. But if this is a straightforward instructed variation, and if a large scale, variation is introduced as an instruction by the employer, which would be imprudent for them, then I would say there is less room for the contractor to negotiate in this regard. But of course, they can raise a claim in relation thereto for the additional compensation, for additional relief. And if the engineer won't approve, most likely they wouldn't. In that case, they need to operate a dispute clause in that contract. But if let's say if I were the adjudicator who would look at such dispute, then of course, depending on the particulars of the case, but I would say it would be a difficult case for the contractor. Why? Because what he agreed in the first place is not only the original scope, it's original scope plus variations or minus variations. This is his commitment in the first place. He can challenge if these variations are significantly different from the original scope. That he can challenge. He can challenge the duration of the variations is so long that whatever financial, especially in relation to resourcing forecasts of the contractor are no longer valid. So yes, he can make these claims, and he has to have a watertight submission in this regard. But again, I would say it would be a difficult, it may be a difficult one for the contractor. But when it comes to employer culpable delays, because the originator of this question, he doesn't distinguish the reasons of the prolongation of the delays. He says the project is delayed for about 5 years, I think, right? A 3-year contract extended 5 years, so it's a 2-year extension of time, which is significant. But he doesn't say how much of the 2 years is coming from variation and how much is from employer culpable delays. Now I'm talking about the employer culpable delays, employer delays. I would say there's more room under the contract and the law in this regard. Because first and foremost, if the contractor is right about his EOT submission, then he can include all such costs into his EOT submission. And even in case of a dispute, I mean, when even the engineer does not accept this claim, if the contractor escalates this dispute to the DAB or to arbitration or whether, he would have a much stronger chance. Why? Because the employer did something wrong. Actually, these things, guys, it's a breach. It's a breach of contract by the employer. But remedy and the procedure for claiming relief is also defined in the contract. Having these procedures within the contract does not mean that it's not breach of contract. No, the contract, the employer is in breach of contract. But how and to what extent the employer will be responsible for such breach is also defined in the contract. So in that case, I think there is more room for the contractor to recover such costs, because in that case, it's cost arising from the other party's breach. So I would say there is more room for more room for the contractor to recover, such losses if they are a part of the EOT claim submission. The last question I have, can we expect to be successful for cost reimbursement claims on disruption caused by the COVID-19 pandemic? And what's the best strategy to adopt under FIDIC 99? Please quote and such references, case references. Okay, so the thing is, FIDIC, they published very good and free guidance memorandums in relation to COVID-19, and they recently published another one in relation to the war in Ukraine. This is the link which you can find these memorandums from. There are 4 memorandums. The first one is FIDIC Contracts guidance on the effects of inflation and the unavailability of goods and labor following the global COVID-19 pandemic and the war in Ukraine. The second one is guidance memorandum COVID-19 impact to the consultant services under the FIDIC suite of contracts and agreements. So this is for consultants. Third one is COVID-19 guidance memorandum for users of FIDIC standard construction forms of contract. This is for works contract. And COVID-19 guidance memorandum for on-site working and project team organization. Go through these guidance memorandums, please. There are very good examples. They introduce some scenarios. I think 4 or 5 scenarios, each with different factors, and they provide a very good insight in this regard. But long story short, if you are after relief under FIDIC contracts, the best chance you get, the best chance is in without terminating your contract, by keeping your business alive, if you will, but getting additional compensation, is to look for opportunities or look for anything which can be attributed to clause 13.7, adjustments due to change in legislation. So a wise contractor would study if and to what extent the government's decrees or instructions or whatever constitute changes in the applicable legislation. In that case, there is plenty of relief for contractors under the contract. But for other things, it's more difficult. I mean, force majeure is difficult. Other things are difficult. At best, you will get an EOT, considering this is a pandemic. A pandemic is, after all, a global epidemic. So this is the situation. But if you can establish a chain of causation between your damages and a government instruction, which would constitute a change in legislation, then I would say yes, you have great chances of success. Okay, so these are the questions I have. There's 2 questions from Clarence. In your opinion, which version of FIDIC 99 and 2017 provides a better mechanism for claims and disputes? I would say easily 2017. I mean, there are some respected professionals out there like Ed Colbert and some other guys. They don't like FIDIC 99, but in my opinion, it's much more improved compared to 99. Is this enough for some 18 years, like 18 years, right? I mean, could they or should they come up with something much more advanced after waiting for 18 years? Yes. Is this enough for 18 years? No. But is it improved? Yes. I would say I would easily go with 2017. Second question is regarding time bars, how binding they really are in countries which are not governed by common law, considering in civil law countries, it's a long-held principle, just claim. Well, Clarence, lucky for you, I delivered a a webinar on this regarding time bars and their use in civil law countries. Duruba is asking from Nepal. Hi to Nepal. Could you please mention what are the new provisions that have gone changes in 2017 revision of the FIDIC 2017? Well, to be honest with you, I haven't. I don't have the copy of the reprinted 2022, so I just have second-hand information in this regard. And off the top of my head, well, the original 2017 wording received some criticism, so they issued an errata at the same time with 2017, but this is like a merger of the errata and some provisions. But off the top of my head, I cannot, answer to your question. As I said, I don't have the copy of the 2072 version myself. I haven't read it, but I saw some reviews in this regard. Some people were still unsatisfied, and some people were like fairly satisfied. But I know for sure that it is a merger. The errata 2017 errata actually had some very important things, So when reading the 2017, make sure that you have the errata with you and you can cross-check what's happening. There are some fundamental corrections there. But the 2022 reprints, as I said, no, I don't have it. Shashidev asks, hi, I'm currently facing a situation where the client keeps on delaying our intern payment. The last one is due over more than 40 days as compared to the agreed 28 days payment time frame in our contract, so we need to suspend the works on what ground? Are you sure you want to suspend the works? I mean, because I don't know what type of contract you guys are using, but if the contractual duration is 28 days and the delay is more than 40 days, so 40 days, which means they haven't paid you since 68 days, right? So if this is the case, then you need to check the provisions of your contract if you want to really suspend the works. In either case, again, depending on the provision of your contract, you should be entitled to financing charges, which is by default in FIDIC books, I think it's 3% above the discount rate of the central bank of the country of the contract currency. Meaning, if you are using United States dollars, it's Fed discount rate plus 3%. So I think it should be like 5.5% or something like that. This, again, if the provisions are not changed, are not altered by the employer, if the provisions are kept as they are, this is an automatic entitlement to the contractor, meaning you don't have to claim it. You just include it in your intern payment application, you get the money. You will be automatically entitled. But again, if you want to suspend the works and if your contract allows you to suspend the works, then non-payment is a valid ground for suspension. Again, but you need to check your contract, because the first recourse usually is slowing down the progress of the works, then suspension of the works. So just be careful about it. And ultimately, again, you need to make sure that this slowing down the rate of progress and suspension of the works actually benefits you. I mean, if you're doing this to teach the employer a lesson, usually it won't end up good for you from a financial perspective. And this is coming by experience, but if this is, of course, your management decision, then yes, you can check your contract, and merely not payment for a specific duration gives legitimate grounds for the contract to suspend the works. Some excerpts, if any, you mean from the time bar presentation, the Ruba? It's a long one. It's a long one. It's a useful one. I recommend you to watch it. And I don't know if we have the slides in the members portal. Jen?
Yes, if you go to the website, instituteccp.com/webinar, which is the link that I'll be sending you, included in the informational email that I send out. If you scroll down to find the correct webinar, so that one was actually a construction clinic. I don't have the number offhand. I think it may have been 25 or 26. But if you scroll down and find that webinar, you will also find the downloadable slides as well.
Okay, excellent. Daruba, it's a very long story. These time bar things and application of time bars in civil law jurisdictions. So I suggest you have a look at it because it's a very long subject, you know. Again, Daruba asks, can the contractor in design and build contract make a claim by showing the errors, discrepancies in the data given by the employer? Yes. Yes, the simple answer is yes. And moreover, not only can claim, this is like an obligation on the contractor. Okay, so usually there is a specific time period during which the contractor, after award, before award, they are the bidders, they are not the contractor. But after award, they are the contractors. So as the contractor, they have, let's say, the obligation to go through all these things. And if they spot any mistakes, any errors, etc., they have to notify the employer. If they don't, they will lose their rights for extension of time and other things. So yes, they can claim. Peter asks, hi Peter. About Sharia law in Saudi Arabia, what's your opinion? Will the regulations of a FIDIC construction contract prevail in front of a local court in Jeddah or Riyadh? Some general statement would be appreciated. Thanks, Peter. Well, it depends, Peter. I mean, it depends on the nature of the court case that will go before them. I would say on commercial things, I mean, if you're just talking about a commercial dispute stemming from a technical subject, I would say the outcome would be predictable, more or less. Why? Because let's say if there's a dispute in relation to soil investigations or strengthening of foundation, structure or earth retaining structure over large scale construction contract, then the dispute, if the dispute is in a technical nature, then the court will anyway appoint an expert who probably would have a fair understanding of the issue from an engineering perspective. But if you're talking about merits of a contract, especially a common law based contract such as FIDIC contracts and AEC contracts and so forth, then I would say it may go, I mean, in any direction. You may have a fairly good response. You may have a completely, unexpected, outcome. So I don't know. That's why when doing business in Saudi, people need to be, and the Saudi government, or like similar governments in the Middle East, they are not very prone. They are not happy with the idea of their authority being challenged literally anywhere else meaning outside the courts of their homeland. Therefore, the contractors need to be very careful in this regard. If the employer, and most likely they will, if they are adamant in this regard, if they don't accept any ADR means, no arbitration, no adjudication, etc., then they need to evaluate the risk of late payment, the risk of all these things going south, and come up with a contingency budget on relation to these such things. Otherwise, they will end up losing money big time. So this would be my recommendation. No problem, sir. All the time for you. Anytime for you.
Okay, that looks like you have answered everybody's questions. So I guess that it's time to speak now or forever hold your peace to those of you in attendance. Yeah, thank you, Cagdas, for all of your insights today.
No problem, ma'am. My pleasure.
Good. Yeah, I don't see anything else going into the Q&A box. So I think I will thank you and thank everyone in attendance. It's great to look over at the attendee list and see so many members' names. So thank you all for joining us today. And thank you all for those of you who may be potential members, future members, or you just enjoy our company. All right. Oh, I spoke too soon. Peter says, thank you, Jen and Cagdas.
Thank you,
Great
guys.
session.
Thanks for
Take
your
care.
time. Thanks, Peter. Thanks, Jen.
Yeah, thank you all. Okay, so thank you, everybody. Goodbye.
Bye-bye. Cheers. Bye-bye.